Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everybody! Here we are again, at the precipice of another election. What's at stake for immigration? Well, Forbes and other news sources report that according to a Times cover story, apart from reinstating policies from his first term, such as the Remain in Mexico program for asylum seekers, and Title 42 expelling migrants for health reasons without letting them apply for asylum, a future President Trump will direct federal funding to resume construction of the border wall and introduce several other measures. Among all these initiatives, one particular plan is being focused on heavily by President Trump and his advisors. According to the Time article, quote, the capstone of this program would be a massive deportation operation that would target millions of people. Trump made similar pledges in his first term, but says he plans to be more aggressive in his second. People need to be deported, says Tom Homan, a top Trump advisor and former acting head of ICE. No one should be off the table. Use the military to round up, put in camps, and deport more than 11 million undocumented immigrants. End quote. Not going to let us end on that negative before we even start the show. The Federal Bar Association Immigration Conference is right around the corner in Salt Lake City, and the pod keeps on pushing on. Thank you, patrons, for providing the coal needed by this legal steam engine to keep on trucking. To mix up a bunch of facts in one very strained metaphor. Speaking of strained metaphors, here are 6 cases showing that indeed, life is a roller coaster. Starting off with Sanchez-Perez v. Garland, published by the 6th Circuit on April 30th, 2024. This case is about crimes of domestic violence. To be one, a conviction must first meet the elements of a crime of violence, which is why this case is going back to the BIA. Mr. Sanchez-Perez is from El Salvador and has been in the United States since 1998. He was placed in removal proceedings in 2009, the very day after he pled guilty to committing misdemeanor domestic assault under Tennessee Code annotated section 39-13-111. Mr. Sanchez-Perez is removable because he entered without authorization all those years ago, but he sought non-LPR cancellation of removal. The immigration judge initially held that Mr. Sanchez-Perez couldn't establish eligibility for the relief because he hadn't established that he'd been in the U.S. continuously for 10 years prior to the service of the notice to appear, as that relief requires. But yet, the IJ also held that Mr. Sanchez-Perez warranted relief as a matter of discretion, notwithstanding this conviction, and that his removal would cause exceptional and extremely unusual hardship to his qualifying relative family member. That is, if he had established his 10 years continuous physical presence. Kudos to the IJ for a comprehensive decision that narrows the issue, notwithstanding the fact that the IJ's docket was likely extensive and the 10-year thing was dispositive. The BIA affirmed the IJ's decision, but then it remanded upon a motion to reopen when Mr. Sanchez-Perez presented additional evidence to establish his 10 years continuous presence. Looks like he was on a path to a grant, given the IJ's prior findings. Not only that, but on remand, Mr. Sanchez-Perez noted his intent to apply for cancellation of removal under the Violence Against Women Act, or VAWA. Seems like he might have had a complicated relationship. Much easier to satisfy VAWA cancellation elements if the requisite abuse or extreme cruelty by a U.S. citizen or lawful permanent resident spouse is present, of course. But then, DHS alleged for the first time on remand that he was barred from both cancellation of removi, because actually that conviction matched the definition of a crime of domestic violence at INA Section 237A2EI. And that, according to DHS, was because of recent Sixth Circuit and Supreme Court precedent, namely, from the Supreme Court, United States v. Castleman, that pesky decision. On remand, the IJ agreed with DHS on the crime. Quote, cases of domestic violence involving fear of bodily injury due to the special volatile and dangerous conditions in a domestic dispute qualify as crimes of violence, end quote. Reasoned the IJ. Looks like relying on some dicta from U.S. v. Castleman. The BIA affirmed with a more nuanced elements-based analysis, reasoning that under the standard articulated for crimes of violence in Castleman, that here, quote, because all of the types of bodily injury under the statute involve a use of force capable of causing physical pain or injury to another, end quote, the Tennessee crime matched the definition of crime of violence. Now, the sentence almost surely wasn't for at least a year of imprisonment, so it couldn't be a crime of violence aggravated felony, but because it was domestic in nature, it met the definition of a crime of domestic violence, thereby barring Mr. Sanchez-Perez from all forms of cancellation of removal. Or so the BIA thought. The Sixth Circuit remanded. As we know by now, a statute is only a crime of violence if the defendant must have used, attempted to use, or threatened to use physical force against the person or property of another. And a crime of domestic violence must require all those elements required of a crime of violence. Now, Supreme Court precedent tells us that the use of, quote, physical force means violent force, that is, force capable of causing physical pain or injury to another person, end quote. Tennessee assault is defined at Section 39-13-101. That assault definition is encompassed in Mr. Sanchez-Perez's specific conviction. And that definition reads that, quote, a person commits assault who intentionally or knowingly causes another to reasonably fear imminent bodily injury, end quote. Not so great for Mr. Sanchez-Perez's argument. However, Tennessee law defines bodily injury as used in that definition at Section 39-11-106A3. And it includes, quote, a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty, end quote. Emphasis by the court. That's a lot of things, and it lets Tennessee criminalize more people for doing more things. But it also takes the statute out of the crime of violence territory. Quote, the Tennessee definition of bodily injury more broadly includes mental harms, and a defendant can commit assault by intentionally causing a victim to fear mental harm or impairment of cognitive function, end quote. No physical force or threat of physical force required at all for that one. Apparently, the Sixth Circuit said as much with a similar Ohio statute in an en banc decision, United States v. Burris, so there's that too. And Tennessee state case law supports this holding, albeit under some unpleasant other factual circumstances. But still, no force necessarily required. United States v. Castleman doesn't counsel otherwise, as government always argues it does. While Castleman may have effectively lowered the standard for what constitutes violent force, and may truly is the operative word, quote, Castleman explicitly clarifies that its rule does not apply to 18 U.S.C. Section 16, the federal definition at issue here, end quote. That is a huge quote to remember if you take nothing else from this decision. The Sixth Circuit just said that United States v. Castleman from the Supreme Court has nothing to do with the crime of violence definition. Domestic violence cases may be serious, but they're still covered by 18 U.S.C. Section 16A, as are, of course, aggravated felony crimes of violence, explained the court. And for good measure, in a footnote, the panel posits that prior precedent about Tennessee aggravated assault and whether they are crimes of violence might no longer be good law in light of the en banc decision in Burris out of the Sixth Circuit. Take it in. And so, congratulations William Patrick York II for petitioner. I can only imagine this is getting sent back from Mr. Sanchez-Perez to be granted non-LPR cancellation of removal. It's been a minute since we had a big crimmigration win, so I've got more. Note, in so holding, the Sixth Circuit states, quote, one could plausibly cause such harm without using or threatening violent physical force, end quote. That is the mental stuff. The Sixth Circuit made this statement without first identifying Tennessee case law where someone was convicted for causing mental harm without physical force, although it does mention cases a bit later. In fact, before it mentioned those cases, the Sixth Circuit states that, quote, by pointing out that possibility based on the text and application of the statutory definition, Mr. Sanchez-Perez has shown that his crime is not categorically a crime of violence, end quote. That seems important to me, too. As I so often discuss on the podcast, the Fifth Circuit appears to be the only circuit where non-citizens must first establish a realistic probability of overbroad application of a statute, even when the statutory text is clearly overbroad. But certain very smart Sixth Circuit practitioners, who I will not name, have told me that it's not quite so clear in the Sixth Circuit either. Now true, here the Sixth Circuit later tethers its realistic probability holding to that Tennessee case law, applying it overbroad as well, but I don't know, those sentences I just mentioned about the text seem pretty clear to me. Keep an eye out on other panels in the Sixth Circuit to see if any panel definitively recognizes what all the other circuits except the Fifth have. Overbroad text alone satisfies the realistic probability test. And that is Sanchez-Perez v. Garland. Two from the Sixth Circuit. Next is Saleh v. Garland, published by the Sixth on May 2nd, 2024. This case is about cat protection. Mr. Saleh is from Iraq and received refugee status in the United States in 2010 and later became a lawful permanent resident. But a few years later, he was convicted of accosting children for immoral purposes and using a computer to commit a crime. The Michigan statutes aren't listed, but everyone seems convinced that he's removable. An IJ then denied asylum and cat protection. Mr. Saleh's fear was based on the fact that his, quote, wife had previously been threatened and harmed by two militias because of his work with the United States Army and because of their mixed marriage. Mr. Saleh being a Sunni Muslim and his wife being a Shia Muslim, end quote. Mr. Saleh did not appeal, but moved to reopen his proceedings in 2018 based on alleged changed country conditions. He sought only deferral of removal under the Convention Against Torture. He brought an expert report and other evidence to show that now, quote, Iraqi officials were suspicious of those who returned to Iraq after being removed from the United States, that his past experiences working for the United States Army elevated his risk of torture, and that his criminal convictions in the United States also enhanced his risk of torture, end quote. I seem to recall a similar one of these out of none other than the Sixth Circuit 2 weeks ago in Abdullahad v. Garland. And whoa, DHS brought its own counter-expert witness. How about that? Or at least a report from that witness. But nonetheless, the immigration judge granted Mr. Saleh's motion to reopen. In reopened proceedings, however, DHS argued that Mr. Saleh's expert witness wasn't actually an expert. And Mr. Saleh, for reasons unexplained here, agreed. So Mr. Saleh has no expert in his reopened proceedings. DHS, on the other hand, brought that expert in to testify, it appears, who was certified as an expert. Such circumstances have literally never been seen before anywhere, much less on this podcast. Not only did the IJ eventually find Mr. Saleh not credible, but totally expectedly, the IJ deemed DHS's expert witness more persuasive than Mr. Saleh's non-expert witness. The BIA affirmed the denial of cat deferral in these reopened proceedings, as did the Sixth Circuit. Now, I don't usually do this, but a lot of this actually did come down to the identity of the proffered expert who became a fact witness later, Daniel W. Smith. The Sixth Circuit is, quote, well acquainted, end quote, with him, and apparently has taken somewhat different positions on his qualifications throughout its different panels. Nothing against Mr. Smith, and I definitely don't know him, but he may not be the best expert witness anymore if only given the heavy litigation surrounding him and the fact that he was designated not an expert in this decision. In any event, said the Sixth Circuit, Mr. Saleh's counsel conceded that Mr. Smith should be treated as a fact witness. The concessions of attorneys in immigration court, including those of DHS attorneys, are quite important. Don't just take it from me. Quote, in a removal proceeding, petitioners are bound by the concessions of their attorneys to the IJ unless they can show ineffective assistance of counsel or some other egregious circumstances, end quote. I don't know, maybe prior counsel didn't have a good reason to concede the issue, because petition for review counsel, who appears to be BIA counsel as well, kind of alleged ineffective assistance. But it appears that they didn't file a bar complaint. So it was all waived to the Sixth Circuit, that is, whether the concession was ineffective assistance. Nor did Mr. Saleh, quote, ask the BIA to relieve him of his attorney's concession because of egregious circumstances, end quote, which I guess is a thing. But because of all that, Mr. Saleh is bound with his fact witness. Facing off his fact witness, who didn't actually witness anything bad happen to Mr. Saleh in Iraq, against DHS's expert witness, well, it's going to be hard to win cat deferral, and Mr. Saleh did not. Back to Abdulahad. It is now the law in the Sixth Circuit that the cat analysis requires the IJ and BIA to aggregate all possible sources of torture. Although Abdulahad, of course, hadn't been issued yet, it was kind of the law well before from the BIA, and the Sixth Circuit believed that the IJ and the BIA so aggregated here. What's required of aggregation, though? Kind of left open by Abdulahad. Need IJs assigned a percentage number to the various forms and then add up those percentages? Kind of like what happens in the Third Circuit? Or is it a more holistic approach, in totality, as applied most everywhere else, including the Seventh Circuit? It's the holistic one in the Sixth, said the Sixth. And this panel believes that the IJ and BIA did so by discussing all possible harms and saying that they hadn't met the more likely than not standard. Probably didn't help that Mr. Saleh was deemed not credible. Nor to the court did it help or hurt that DHS's expert then became U.S. Assistant Secretary for the Bureau of Conflict and Stabilization Operations. Because of all that, Mr. Saleh remains subject to removal to Iraq. And that is Saleh v. Garland. Moving on to Loredo Rangel v. Garland, published by the Fifth Circuit on May 1st, 2024. This case is about asylum. It appears that Miss Rangel and her minor daughters are from Mexico and brought asylum claims in the United States. Quote, their applications rest on the theory that the Mexican Navy will persecute and torture them to dissuade Miss Rangel from further pursuing her ongoing campaign to hold the Mexican military responsible for the disappearance of her son, end quote. A lot packed in that quote in a pretty short decision. An IJ and the BIA denied this claim, and the Fifth Circuit affirmed. The Fifth Circuit first affirmed the no past persecution finding. Rejecting Miss Rangel's arguments, the court held that, quote, extreme treatment is not a more demanding standard. It is the standard for establishing past persecution for purposes of demonstrating asylum eligibility, end quote. Emphasis by the court. The Fifth Circuit recognizes that past persecution need not be physical, and that's not nothing, y'all, but it still must always be extreme, said the court. There is no question that non-citizens, quote, can establish past persecution through non-physical harms. Indeed, mistreatment can take other forms, such as the deliberate imposition of severe economic disadvantage, or the deprivation of liberty, food, housing, employment, or other essentials of life, end quote. The Fifth Circuit just believed that the Mexican Navy, having, quote, searched, ransacked, and robbed her then vacant home, end quote, and then driving by the next day looking for her and her daughters didn't rise to the level of past persecution. It wasn't, quote, so severe that it constitutes a threat to life or freedom, end quote. The Fifth Circuit believes that this finding is supported by the law of many circuits. And importantly, Ms. Rangel had not, quote, shown that the ransacking caused serious or permanent damage to her home, end quote. I wonder if it had. Without a home, that would be the deprivation of housing. Just saying. Nor was that next day drive-by menacing or imminent enough, said the Fifth Circuit. Halfway through the decision, we learned kind of why all this is happening. Quote, in the 4 months leading up to the ransacking, Ms. Rangel had publicly spoken out against the Navy on numerous occasions, appearing on news media and meeting with various Mexican and U.S. officials, end quote. I guess it was because her son was missing and the Navy might be responsible? The decision doesn't say, but she clearly has beef with the Mexican Navy. This case wasn't like other Fifth Circuit and out-of-circuit precedent where harm or retribution was imminent and expressly threatened. Quote, though we are sympathetic to Ms. Rangel's fears, the threat she alleges nonetheless falls short of the organized, relentless campaign of intimidation, extortion, and murder exemplified, end quote, by other precedent. Without the benefit of a past persecution finding and the presumption of future persecution that it entails, Ms. Rangel could not make that showing on her own. Reasoned the court. Particularly as her claim to future harm was based on the same facts as her past persecution claim that the court didn't deem sufficient. And this is even though another son apparently also disappeared, but there was no evidence that the Mexican Navy was involved with that son's disappearance. Similar reasoning on cat protection as well. Summarized, the Fifth Circuit didn't see error in the BIA's analysis, much less reversible error. So Miss Rangel and her daughters lost their case. And that is Loredo Rangel v. Garland. Next is Donis-Hernandez de Cabrera v. Garland, published by the First Circuit on May 2nd, 2024. This case is about asylum. Ms. Cabrera and her husband and their 2 children are asylum seekers from Guatemala. Their claim began when Ms. Cabrera decided to open a second-hand clothing store from her family home, using Facebook to advertise. She decided to use Facebook rather than advertise around town because the Mera 18 gang frequently extorted business owners in her part of Guatemala City, known as San Gaspar. The gang found out about her anyway and extorted her. Someone threw a cell phone through her home window and then it rang. When she answered, quote, a man identified himself as a member of the Mera 18 gang and demanded that she pay the gang 10,000 quetzales in a week's time because she was running a business, end quote. He'd kill the whole family if she didn't pay, and he said that he knew where her husband worked and where one of her daughters went to school. Quote, understandably scared out of her mind, she said, okay, and hung up, end quote. Explains the First Circuit. The family didn't trust the police and so, after discussing it, decided to flee Guatemala to the United States because that's where Miss Cabrera's husband's father lived. The daughter left school, the husband quit his job, and they left everything that they owned behind, seemingly trekking through Mexico for the United States. They were placed in removal proceedings to bring their Mera 18-based asylum claim, where they did not succeed. And despite its use of very sympathetic language, the First Circuit affirmed the denial. Lots of findings were made below and lots of things were challenged, but the First Circuit focused only on the cognizability, or lack thereof, of the asserted particular social group. By the way, Ms. Cabrera asserted an anti-gang political opinion below, but abandoned it on petition for review. So particular social group or bust. For some exceptionally complicated reasons, the First Circuit believed the only particular social group before it was the group of small business owners. Something that, procedurally speaking, was actually kind of favorable to Miss Cabrera and the family. But the First Circuit still didn't believe that this particular social group is actually, well, a particular social group. Particular social groups must be immutable, particular, and socially distinct. Now, small business owners might be immutable in that someone shouldn't be forced to change it about themselves if it's fundamental to their identity. Assumed but not decided by the First Circuit here, although the Sixth Circuit believed that a similar group was fundamental in Reyes-Galena v. Garland, episode 202. Here, though, Ms. Cabrera didn't provide evidence sufficient to show that this was the case for her, that it was fundamental to her identity. How to do that in the future? Well, show that your client had a, quote, entrepreneurial spirit, end quote, that she opened her business in part for this reason and not just to make money, and that she kept it up when she came to the United States. Also, maybe have your client explain on the stand that, quote, she chose to become a business owner despite being well aware that the Mara 18 gang might target her, end quote. But none of that was shown here, other than through argument, which is not evidence, said the First Circuit. Nor is the group socially distinct in Guatemala, said the court, and at least based on the evidence presented. While the persecutors' views are relevant, here, Mara 18, it's the society as a whole that's the focus under matter of MEVG, and pretty much every circuit post-MEVG. Not shown here. Heck, as I so often lament, how does one explain to a U.S. judge what an amorphous society believes without an expert? In addition to news articles, I once dug deep into foreign language blogs and the comments sections of news articles, saying bad things about my client's group. But I mean, that's not the end-all be-all, and that's not always available anyway. Has U.S. asylum law really got to the point where particular social group cases require an expensive expert? A rhetorical question because y'all can't answer me anyway. Without a particular social group, asylum and withholding of removal are toast. Convention Against Torture Protection doesn't require one, but that was denied too. Looks like there wasn't enough evidence. Department of State country condition reports, for example, are of such a, quote, generic nature that they are rarely dispositive, end quote. Good quote to remember when DHS is relying on the Department of State themselves, but not very helpful here. Nor does anything show that Ms. Cabrera is at an individualized risk of torture with the Guatemalan government's consent or acquiescence. To conclude, quote, as the IJ indicated below, we in no way condone what's happened to petitioners, but for the reasons discussed above, the petition is denied, end quote. The family will be removed. And that is Donis-Hernandez de Cabrera v. Garland. This podcast is sponsored by Driftwood Capital. Driftwood Capital boasts a 30-plus year track record, transacting on more than $3 billion in hospitality assets. Since 2015, Driftwood Capital has successfully implemented the EB5 program into their development deals, helping more than 160 families find a secure path to residency through their projects. Driftwood Capital is a vertically integrated commercial real estate firm specializing in hospitality with dedicated acquisitions, development, lending, and management divisions. Their goal is to create long-term partnerships with its network of more than 1,200 active investors from the United States and abroad while targeting attractive returns. Driftwood's unique approach involves managing all aspects in-house, from developing renowned hotel brands such as Marriott, Hilton, and Hyatt, to managing their portfolio of more than 80 hotels in the United States. If you want to learn more about Driftwood Capital, check out the show notes. And of course, let them know who sent you. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures, but let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents, and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most. your clients, and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. Moving on to Rosas-Martinez v. Garland, published by the 8th Circuit on May 3rd, 2024. This case is about cat deferral. Mr. Rosas-Martinez was brought to the United States from Mexico without authorization when he was 9 years old in 1996. He grew up in this country, and it seems like he fell victim to some of the not-so-great aspects of this country as well. He got involved in drug trafficking in 2019, and he was convicted. It seems largely because of a man named Erasmo, who was engaged to Mr. Rosas-Martinez's cousin, and who then told Mr. Rosas-Martinez that he needed to keep quiet about Erasmo's involvement. Mr. Rosas-Martinez went to jail, unsure about Erasmo. Erasmo, however, had his would-be mother-in-law call Mr. Rosas-Martinez's mother, her sister, 3 times in an effort to learn when Mr. Rosas-Martinez would be released. In support of his cat deferral application and removal proceedings he pursued after his release from prison, Mr. Rosas-Martinez claimed that the Sinaloa Cartel would kill him because the drugs belonged to them, and he lost them when he was arrested in the United States. I guess Erasmo was Sinaloa Cartel affiliated? And you know what? An immigration judge granted cat deferral. But the BIA reversed on DHS's appeal. Then Mr. Rosas-Martinez filed a motion to reconsider with the BIA. That was denied, and now it's all before the 8th Circuit. The 8th Circuit affirmed the BIA and not the IJ. The BIA did not improperly gauge in its own fact-finding, explained the court. Rather, the BIA properly reviewed the IJ's found facts, but believed that they didn't satisfy the Convention Against Torture. Nor were the BIA's conclusions unreasonable. Mr. Rosas-Martinez had never been harmed in the United States or Mexico, and Erasmo's inquiries into his whereabouts were limited and stopped when Mr. Rosas-Martinez's mom asked them to stop. He and Erasmo hadn't spoken since 2020. And, while the BIA recognized that there is corruption in the Mexican police force, country condition evidence also shows that corrupt cops have been prosecuted and police departments purged. While no one is saying it's perfect, it wasn't unreasonable to find that the record did not support a finding that police would consent or acquiescence to the Sinaloa Cartel's torture nationwide in Mexico, as the CAT would require here. Now, matter of JFF governs the CAT analysis, although I have discussed cases on the pod of late where circuits have held that actually, it is not the case necessarily that every link in the hypothetical torture chain must be established to get CAT protection. But putting that aside, JFF governs here, and the quote, IJ assumed that 1, the cartel would find out about Mr. Rosas-Martinez's return to Mexico, 2, it would blame him for the seized drugs and attempt to capture, kill, or otherwise torture him, and 3, the Mexican government will acquiesce to his torture, end quote. That's why the IJ granted CAT deferral in the first place. But the BIA's decision, based on the facts in the record, found that the second and third elements there were lacking, and therefore that the IJ was incorrect. That was okay, said the 8th Circuit. Nor was the BIA out of line in its finding that Mr. Rosas-Martinez could likely relocate within Mexico, which is just one of many factors to consider under the CAT. Nor did the BIA act arbitrarily, despite the fact that, it appears, Mr. Rosas-Martinez presented two unpublished BIA decisions that were very similar, but that went the other way. Smart thing to do, counsel. If nothing else, though, said the Eighth Circuit, quote, "Given the changes in the Mexican government, we do not think it surprising that the BIA's view about the government has changed. The variability seen in the BIA's decisions is not outside of the agency's discretion, and we will not pick one line of the BIA's cases over the other," end quote. Interesting stuff, though, and an argument to continue to pursue. Close case for Mr. Rosas-Martinez, but he did not succeed. And that is Rosas-Martinez v. Garland. Our final case is Cuenca v. Loredo v. Carmen Rojas, published by the 11th Circuit on May 1st, 2024. Can I end with a case about the Hague Act Convention on the civil aspects of international child abduction? I've never done one of these on the pod or in real life, but I did have a bit of exposure to them when I worked in federal court. They're very interesting and immigration adjacent, so I've always had my eye on them. This one seems particularly immigration heavy, as you'll see. Why not do it then, right? Change it up from all the asylum and crimes? The United States and many countries are signatories to the Hague Act Convention on Civil Aspects of International Child Abduction. Essentially, the convention lays out rules and provides a cause of action in U.S. federal court for situations where one parent is in the U.S. and the other is not, and one of the parents takes a child to or from, I believe, the United States. Where is that child to remain? Heavy stuff. I could be wrong, but this might be the legal basis for the whole Elian Gonzalez debacle way back when. Not so dissimilar to what happened here. The 8-year-old child at issue, using the acronym CR, is a citizen of Venezuela, as are both of his parents. Carlos, the father, lives in Venezuela. Yari, the mother, took CR from Venezuela 3 years ago without Carlos's knowledge or permission and brought him to the United States. They've lived in the same apartment in Jacksonville ever since. Neither Yari nor CR currently have permanent legal status in the United States. Carlos brought this action in the Middle District of Florida 20 months after Yari absconded with CR. Pretty remarkable thing that a non-citizen not in the United States can bring a case in U.S. federal court, but again, that's the point of the Hague Act. Quote, "The convention and its implementing legislation generally require the immediate return of a child to his home country when the abandoned parent files a petition for return within 1 year of the wrongful removal of the child," end quote. And everybody agrees that the removal of CR was wrongful. But Carlos waited 20 months. As such, quote, "The convention allowed the district court to refuse his petition for return if it found that CR was settled in his new home in the United States," end quote. There's your issue. Is CR settled such that Carlos's Hague Act case fails? The district court so found. But what about the fact that neither CR nor Yari really have lawful status? That's the main issue that the 11th Circuit decided to tackle on appeal. Under the convention, there's a preference for custody to be decided in the home country, which is usually the, quote, "habitual residence," end quote, of a child. But after a while, the habitual residence of a child can change, right? And if the focus of the Hague Act is the best interests of the child, then so too might that preference. Per the convention, that time flips a bit after a year. Quote, "In that case, the court is not required to order the return of the child if the respondent parent shows by a preponderance of the evidence that the child is now settled in the new environment," end quote. Now, even if that is shown, a federal court still has discretion to order the child's return abroad. But that is a, quote, "infrequent occurrence," end quote. Again, everybody agrees that Yari totally wrongfully removed CR from Venezuela in violation of a custody agreement and Venezuelan law. There is no dispute. And for months, Yari assured Carlos that she would return to Venezuela with CR soon, so he could attend school. But that appears to have been a ruse. She moved in with a new boyfriend in Florida and enrolled CR in a local Florida school and applied for asylum for herself and CR. As we know, after 6 months, and assuming you get your card, that permitted her to work, and she bought a car, got a job, and enrolled CR in an after-school YMCA program. 7 months after coming to America, she admitted that she had no intent to return to Venezuela. 2 months later, so 9 months in, Carlos visited CR in Florida. I guess Yuri and he, or at least he, had tourist visas? He tried to convince Yuri to return with CR, but she refused. So Carlos filed a custody action in Venezuela. The Venezuelan courts awarded full custody to Carlos. Yuri did not comply with the Venezuelan order, and, quote, in the meantime, CR flourished in his new home. He and Yuri continued to live in the same apartment in Orange Park, Florida, and took trips to visit a cousin in Orlando and family friends in South Carolina. He learned to speak and read English, earned good grades, and made friends in the neighborhood at the YMCA and at school. He took swimming lessons and karate classes. He won school awards for academics, good character, helpfulness, citizenship, and perfect attendance. At the YMCA, he won the Most Friendly Award for making the most friends throughout the year, end quote. CR also maintained his ties to his family in Venezuela. He spoke with his father Carlos and his uncles and his grandparents almost every day. And his father visited him in the U.S. 3 times. After 2 years, CR told his father that he wanted to stay in the United States. Carlos filed his Hague Act case a little bit before that, 20 months in. The district court judge held that for all the reasons just discussed, CR was settled in the United States. The district judge even made Yuri file her asylum application in federal court under seal for the federal district court judge to consider. Not to grant her asylum or not grant her asylum, just to consider what the claims were. In making this "are you settled or not" determination, the federal judge considered CR and Yuri's uncertain immigration status. At the time, they simply had an asylum application pending, which didn't give them status, as we all know, but also it permitted them to lawfully live and work in the United States. Not only that, but Venezuela had recently been granted TPS as a country, it appears, and Yuri and CR might be eligible for it in the future, at the time. So they probably wouldn't be removed anytime soon, reasoned the federal court. Even though Yuri acted unlawfully, all acts weighed in favor of CR remaining in the United States. And again, particularly because Carlos waited over a year to file this action. The 11th Circuit did not reverse the district court judge. Whether a child is settled is a totality of the circumstances analysis that is primarily factual, meaning that the matter is reviewed for clear error. Hard to win with that type of appellate review. To cut to the chase, the child and parent's U.S. immigration status is one appropriate factor to consider, explained the 11th Circuit. It looks like Carlos couldn't and really didn't challenge that CR is excelling in the United States and that he's pretty much settled, but argued mainly that CR's lack of permanent legal status made it such that CR couldn't be settled in the U.S. He might get deported, right? Carlos also argued that, quote, discrepancies between Yuri's testimony at the evidentiary hearing and her application for asylum show that the application was fraudulent and has no chance of success, end quote. Brutal arguments being made. Plus, apparently they weren't eligible for TPS yet, unless and until TPS for Venezuela was redesignated, which I do believe it was eventually, but maybe not at the time of the district court action below. And yes, said the 11th Circuit, a lack of immigration status is a factor that weighs against a child's settlement, quote, especially if removal seems imminent, end quote. But like in other circuits, there isn't a categorical rule that lack of permanent status equates to no settlement. Just look at the Pilgrims in Plymouth Rock. That's a very bad joke, and I apologize for it. Facial viability of a pending immigration application is also an appropriate factor to consider. So like a mini-analysis of Yuri's asylum claim in federal court? Kind of. Quote, in general, district courts have no role in immigration proceedings and are not in the best position to predict how an immigration judge or the Board of Immigration Appeals may rule, end quote. I wonder how that quote might come in handy in another context someday. In any case, the federal judge here did not believe Yuri's asylum application frivolous or her testimony riddled with material discrepancies. At the end of the day, weighed against all the other facts showing that CR is settled in the U.S., the district court didn't err, said the court. And even the U.S. government, in granting TPS, recognized that a, quote, severe economic and political crisis is ongoing within Venezuela, end quote. Affirming the district court on settlement, the 11th Circuit did not believe this the rare case where a settled child should be removed. So Carlos did not succeed on his appeal, and CR remains in the United States. Before we go, and in the interest of completeness, another one of these type of cases was issued in the 7th Circuit this week. But it was a wonkier one full of jurisdictional stuff. I feel like one Hague Act case is enough for this week's pod, no? Another rhetorical question. And that is Cuenca Figuerero v. Carmen Rojas. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.